All right, so we're going to get started once again. It's 12:45. I hope everybody got a chance to grab some food, grab some water, and yeah, welcome back this afternoon. So, this is the spring Planning and Zoning Conferences Planning Board Housekeeping session. My name is Brendan McDowell. I'm a principal planner here at BEA and with the Office of Planning and Development. I am joined here by Director Heather Shank, who is the Director of the Division of Planning and Community Development. And we will be giving this presentation together. So I'm going to kick things off. So here's the agenda for today. Oh, and as a quick reminder, you can use the chat function on Teams here to ask any questions. Please put your questions in the chat kind of throughout the presentation, and we will try to get to them at the end. And again, as a reminder, the session at the very end of the day, so the session directly after this one, is entirely there for Q&A. So if we can't get to your questions here during this session, we're going to roll them over. And even some questions, if we hear them multiple times throughout the last couple sessions, we might ask them again at the very end as well. Oh, I did see somebody ask, and I'll just address this really quickly before we get started, to let them know when the recordings would be available. And just so everybody knows, we will be sending out a follow-up email when these recordings are posted on our YouTube channel. And so you can reference back to them at any time or rewatch and check things out. So, all right, with that out of the way, let's see. So here's our loose agenda for this session. We are going to be going over some similar topics. We might be going in a little bit more detail on others. And you know, there's generally going to be some overlap between the three sessions, but we might have people here who didn't make it to the other session. So, all right, here we go. So a community can create a planning board through RSA 673:1 in the form of a warrant article to be voted on by the legislative body, which is the town meeting, town council, or city council form of government. So after the board is established, then the election of officers must be completed. So after the elections, then the bylaws or rules of procedure are created. Should be here. The bylaws or rules of procedure should spell out the order of business in which the board operates, explain the role and purposes of the board's officers, when the board meets, the role of alternate members, process for recusals, removal of board members, etc. After the bylaws or rules of procedure are approved by the board, they are put on file with the city or town clerk. Once the board has officers and bylaws in place, the creation and adoption of the master plan is next. And I know John Christ talked quite a bit about master plans. So the master plan is not considered a land use regulation. However, it is required to be able to adopt land use regulations. So I think of master plans as more of the town's vision board of what they'd like to see in the future, more than a regulatory document, but guiding those regulatory decisions. So a master plan provides the legal standing for the community and planning board to adopt and implement zoning and land use regulations. A master plan, like land use regulations, is a community-based plan, meaning the community has shared their ideas and desires for how they want their community to grow and where and what types of development the community wants. So this is very important. So the master plan by New Hampshire law is required to have a vision chapter and a land use chapter. So just those two chapters. Other chapters, it can also include other chapters like recreation, conservation, housing, community facilities, transportation, are all optional chapters that could be included. And it would be a good idea to include those other chapters, but the only two that are necessary are the vision chapter and the land use chapter. So after the planning board adopts the master plan, then work can begin working on creating any or all of the following: the capital improvement program, or CIP, the zoning ordinance, and subdivision regulations. This chart shows the link between the master plan and the land use regulations, where you can't have one without the other. So, and that's kind of the general order that everything flows in. So subdivision regulations must be consistent with the goals of the master plan as well as the zoning ordinance for location and type of housing. Subdivision regulations need to outline the requirements for a completed application, checklists, fee schedule, and thresholds for major and minor subdivisions, etc. While RSA 674:36 doesn't require subdivision regulations to include a waiver provision, it's best practice to include such a provision in order to have that safety valve from any regulation similar to what a variance is for zoning. So, and John talked a lot about waivers in his presentation earlier. Subdivision regulations are based on the premise that a new subdivision is not and should not be separate from the community, but an integral part of the whole community, by which it efficiently connects with the municipal pattern of streets, sewers, water lines, and other municipal facilities that provide essential services, as well as vehicular and especially emergency access. If there is concern, for example, with the quantity or quality of surface or groundwater, which is RSA 674:36, provides authority to protect water sources by requiring in the subdivision regulations documentation of adequate water supply free from contamination to service the proposed subdivision. The adoption and amendment of subdivision and site plan regulations can be done at any time throughout the year, as they do not have to go to the town meeting for approval, but they do follow the noticing requirements for a normal public hearing. So site plan regulations are to ensure uses that are permitted by the zoning ordinance are constructed and operated in such a way that they fit into the area in which they are being constructed without causing drainage, heavy traffic, lighting, or similar problems. They apply to commercial, industrial development, multifamily buildings, and changes of use in businesses. They may include criteria about traffic, parking, utilities, landscaping, lighting, etc. The written purpose of site plan regulations outlined in RSA 674:44, Roman numeral 2, is relatively broad to allow for the inclusion of other requirements in the site plan review regulations, such as inclusion of stormwater management standards. Like for the subdivision regulations, RSA 674:44 also specifies the administrative functions and procedures site plan regulations must include, i.e., purpose, procedures, standards for completed applications, and checklists, as well as enforcement and administration policies. Unlike for subdivision regulations, site plan regulations must include a provision for waivers from the regulations/application requirements. So planning boards and their meetings, they can hold public hearings and hold public meetings. So sometimes you must be very specific when dealing with the public in explaining public meetings and public hearings because they are not the same thing and they're often lumped together. So a public hearing is a meeting duly announced and advertised in advance that is open to the public and called by the town council, board, or commission of the town for the purpose of taking formal public comment, both in favor and opposition to a proposed action. So a public hearing, most land boards hold public hearings like the planning board, zoning board, historic district commission, heritage, agriculture, and housing commissions. They hold public hearings to address proposals or applications presented to them. Formal applications and proposals and notice to the public are key components of whether it is a public hearing versus a public meeting. So a public meeting is more of an informal meeting, hearing, or workshop of a municipal board, committee, commission, or governing body, or the representatives, where the public may attend and may provide input. So it's not necessarily a must. So land use boards and governing bodies like selectmen, city council can hold public meetings where they take care of town business and at some point allow public input on broad issues. So planning board work sessions are also public meetings. So the planning board application process, 676:4. So the number one role of the planning board is to accept and decide on applications as laid out in RSA 676:4. There is, if there is any statute to know in detail as a planning board member, this is it. So applications must be submitted to the planning board according to the board's meeting and deadline schedule, or at a minimum of 21 days before the public hearing on the application, according to RSA 676:4, Roman numeral 1B. The planning board shall specify that an applicant needs to submit in order for the board to invoke jurisdiction and be able to make an informed decision. So in order to achieve the requirements of 674:4, the planning board must adopt subdivision and or site plan regulations. The subdivision and site plan regulations should include the information for what is needed to be included in applications in order for them to be complete. So we went over this quite a bit in John's session as well. For a planning board to determine an application is complete, the application must include sufficient information to allow the board to proceed with consideration and make an informed decision. So checklists. Checklists are part of the submission requirements for each application that make it complete. So let's talk a bit more about checklists. It means that you, the planning board, get to decide what information you require in an application you are asked to review, and it should be outlined in the site plan and subdivision regulations and made available to the public through a checklist. So checklists are a really good idea. Checklists are how the board can meet the requirements of RSA 674:36 and 44 that says specify by regulations what constitutes a complete application. So the board should adopt checklists as part of their subdivision and site plan regulations. They are for the public, the board, and the applicant to use to know and understand what is expected and what is required of them in order for the board to comply with 676:4 as to what makes a completed application. So example checklists can be found at the end of the Office of Planning and Development, which is us, Planning Board Handbook. I've put that in the chat a few times. I will put it in the chat again after I've completed my section. Absolutely encourage you to check it out. It's got a lot of information in there, and we have example checklists in there as well. So before an application can be accepted or considered complete by the planning board staff, the board or the board's designee should review the application to see if it is complete, which includes a review of the submitted application against the items required by the checklist and or the regulations, like fees, plans, reports, etc., and identify if there are requested waivers for specific items. So we've gone over waivers quite a bit, um, but I'll go through this kind of quickly. So as previously mentioned, a mechanism for an applicant to request a waiver from meeting specific requirements of the site plan review regulations is mandatory, but allowing waivers from subdivision regulations is optional. However, we recommend allowing waivers from both applicants must show good cause that strict conformity to the regulations would cause an unnecessary hardship, and a waiver would not go against the spirit and intent of the regulations. Waiver requests must be in writing and should identify the section of the regulation in which the waiver is being requested. The board should be clear in their reason for granting or not granting the waiver. While each board does it differently, best practice is to vote on waivers individually so that they are not in a position of voting up or down on all of the applicant's requested waivers. So again, waivers should be voted on individually, not as a group. So when reviewing waiver requests, the board should ask, will this affect the information we need in order for us to hear and decide on the application? Yes or no? Is there enough information to make an informed decision based on your regulations? Yes or no? Work with the applicant to get the information you need and explain your reasons clearly and in writing as to why you are not granting the waiver, and refer to your regulations for support. If all the waivers are granted, the application can be accepted as complete and the public hearing can begin. This can be done by the same meeting as long as it was notified in a way to the public and abutters. If all the waivers are not granted and the applicant is not willing or able to provide additional information to satisfy the waiver requirements, which they were not granted, the application can be denied. So application completeness. So after the application is filed, the planning board at its next regular meeting or within 30 days of application delivery shall vote on the application completeness. As a reminder, a complete application means sufficient information is included or submitted to allow the board to proceed with considerations and to make an informed decision. If there is a question about whether an applicant has provided sufficient information for the application to be determined complete, it is better for the board to determine the application isn't complete and to continue the completeness review to a future meeting date, at which date the applicant can supply additional information rather than prematurely determine an application is complete when it is not, and then be in a position of asking the applicant to supply additional information which should have been in the original application after the 65-day review and deliberation clock to reach a decision has begun. So a planning board has 65 days from the application completeness determination to approve, conditionally approve, or deny an application. After the application is accepted as completed, you hold the public hearing, having given notice to the abutters and the public. The planning board is free to consider, review, and discuss proposed conditions of approval for reasons for denial while the public hearing is still open. Provide last chance for applicant and abutters to comment, and then close the public hearing. It's very important to close the public hearing. Begin deliberations. Discuss among the board and staff potential conditions of approval or reasons for denial. Be clear with the conditions and reasons. Include what you see fit for compliance with the regulations. If it takes 14 conditions to approve if it takes 14 conditions of approval to get the application and development uh, that you want, then so be it. Don't pay attention to the number of conditions of approval. It is better to have many conditions and be clear on what was approved and what is expected than have to enforce a compliance issue later. So do not count on what was said at the meeting or in the minutes to be used for approvals, denials, or enforcement. So get it in writing. So to recap, the planning board's role is to accept the application as complete or not and review and approve / deny formal applications that are submitted. So the chair's job is to allow the applicant and abutters to speak and be heard. They do not have to allow repetitive comments and can enforce time limits if stated in the rules of procedure. If uncertain on whether to accept an application as complete or not, don't hesitate to continue acceptance. Or if uncertain on whether to accept an application as complete or not, don't hesitate to continue acceptance. Okay, utilize the existing regulations in your decision-making process, i.e., does the application meet the master plan goal, site plan, or subdivision regulations? And don't be afraid to consult your board or municipal attorney for guidance. So another option for helping this process is a TRC, or Technical Review Committee. So technical review committees are a great tool to allow for collection of comments from various municipal staff about site plan application. So as outlined in RSA 674:43 and 674 :43 Roman numeral 3 is where the technical review committee gets its authority to review site plans. So the local legislative body of a municipality may, by ordinance or resolution, authorize the planning board to delegate its site plan review powers and duties in regards to minor site plans to a committee of technically qualified administrators. So what is a TRC, or Technical Review Committee? It consists of municipal officials and or board of commission members. Whether or not the TRC will serve as an administrative or an advisory committee or another arm of the planning board that has approval authority is up to how the warrant article was voted on by the legislative body. So it can be made up of municipal officials, department heads, or other board or commission members. There is also a chair and a vice chair of the TRC, and it is an arm of the planning board. So the roles, so the TRC roles can be either advisory or have approval authority, and they can and should be included as an important initial part of the development review process. So their responsibility is to provide technical and professional assistance to applicants in the development review process. They inform all of the town's departments of the development projects. They create communication with the planning board, which is overall good for the community from a cooperation and development point of view. So, in the overall benefits of a TRC, they foster cooperation and communication. Um, I think I already said that. So they can assist in they can assist departments with budgets and the CIP and CIP items. They can provide a conceptual consultation review and input. And they also streamline developmental review process for the developer and the municipality, so they can be very helpful for everyone. And with that out of the way, I am going to introduce Director Heather Schenk to continue our presentation.
Great, thank you, Brendan. Taking control now. Okay. So sidewalks. Sidewalks are something that the board can do during the course of an application or before an application. It's an important part, can be a very important part of the decision-making process, depending on what the application is and how complicated it is. It's a meeting. A sidewalk with the planning board is a meeting. It needs to be noticed. Minutes need to be taken, and the public has to have access. So it is the same as a meeting for a sidewalk. I've never actually done one, so I'm not entirely sure how you separate the public from the planning board members. But it is intended to be treated as an opportunity for a meeting. It's good for fact finding and visualizing the details of the development. If there is no site walk scheduled, the individual members of the board can view a site on their own, but they are not allowed to trespass on the property. If it's something that is formally set up by the board, they do have access in accordance with the regulations, but if individual members cannot trespass on the property if they're not done in that context. A site walk can be great for understanding the scale of things. Scale is something that is the most difficult to understand when looking at a plan or even looking at drawings. Understanding the scale of the existing land. Oftentimes you may get a topography, a contour plan, but not really understand what that means in the context of the actual land. So going on a site visit can really help you understand what the land is and what the impact might be of the proposal. Sorry, my slides are, yes, okay, that works. So third-party review. If you do not have the resources to do an effective or the technical knowledge to do a review, if you don't have engineering staff or planning staff or surveyors or anything like that in your municipality, we cannot underestimate the value of a third-party review. Especially if there's any grading or drainage or potential wetlands or sensitive features. If there's traffic impacts, all of these things, you're able to require the applicant to cover the fee for a third-party review. And a consultant that is representing an applicant for the purpose of promoting their project is very different from a consultant hired by the municipality to protect the public interest, unfortunately. But so it's cannot be underestimated the value of getting that perspective of someone who's there to protect the public interest and review the information that's put forward. So experts, consultants can help you understand the project and the impacts. It's something that you should include in your regulations, in your ordinances, the ability to do that. The RSAs authorize you to do that, but you should put it in your regulations so it's clear that it's something that is part of your process, and that there's a process for doing it. So before a project starts, the best way to go about it is to get it when you have a relationship. Hopefully you'll have a relationship with a consultant or multiple consultants. You can get an estimate from them on a particular project and what might be needed for it. And then you have the applicant pay that estimate up front. You put that money in an escrow and then you draw on it. through the course of the project. And it's really important to keep good track what accounts are in, how much money, what are the dates and amounts and withdrawals. It's really important to keep track of all of this so that you have a record. And then when the project's over, if there are any leftover funds, which there often may be, those are returned to the applicant. There are a number of things that consultants can be helpful for. I mentioned basically traffic, wetlands, grading and drainage, especially if there may be stormwater impacts, impacts to neighboring properties or the city infrastructure, the town or municipal infrastructure or water bodies. Your consultant can provide numerous different services. They can help you and make recommendations on a project, and improvements that could be made to the plan. They can provide a different perspective of what's being presented, again with the eye towards the municipal interests. And they also can help you establish a basis for approval or denial based on whatever criteria there may be for waivers or variances. What complies with your regulations, that they will be hopefully familiar with your regulations and can evaluate what's compliant with those, what's in the public health and the public safety. Utilized for actual development of the project. So you can have them do inspections for you, or site visits, escrow drawdowns. There are a lot of different things that you can use consultants for to assist with doing your project review. Motions, moving on to motions. So any member of the planning board can make a motion, including the chair. Chairs often don't like to, but they're allowed to make motions as well. Motions should contain what the complete action is, all conditions of approval, which someone asked about, and we will go over in detail on its own in a minute, and any reasons for denial. I think this has been said multiple times today. If you're going to deny something, it has to be on the basis of criteria, public health, safety, or welfare, something concrete related to your ordinance or your regulations that it does not meet. It can't be, we just don't like this, we don't want this here. It has to not comply in some way with the uses of the regulations of your ordinances or your regulations. A failed motion is not the opposite. It doesn't mean that if a motion fails, it doesn't mean, oh, your project fails, move on. You have to keep making motions until a motion passes. You have to continue discussion. If there's a motion to deny the project and that motion passes, then the project has been denied, the application has been denied and no longer can go forward. But a failed motion does not mean that the application does not get approved. So that's something that I've seen myself get a little bit confused about. You have to keep going until you get a motion that passes, whether that motion is to approve with conditions or deny or table or whatever. There has to be a motion. So conditional approval. So conditional approval, there's two types of conditional approval. There is I just happened to see, can a non-voting alternate make a motion? Yes, a non-voting alternate, if they're sitting in the capacity of a member, if they are taking the place of a member who is not present and they're serving in their role as a member to make a quorum, yes, they can make a motion. If an alternate is simply sitting at a meeting where they are not there to make a quorum, or they're not fulfilling their role as becoming a member, it's my understanding they cannot, but I'm not entirely sure about that. We should check with one of our attorneys that we'll have on here later. But if I know for a fact, if they're serving in their role as a member, yes, they can make a motion. So two types of approval. There is condition precedent and conditions subsequent. So there's two types of conditions you can place on something. Let's start there. You can place conditions precedent, which means things that have to be accomplished before they're able to get a building permit or move on with their project. And then there's conditions subsequent, which are usually conditions that are ongoing for the life of the project. So for instance, if you say, oh, well, we approve this, but you can only be open from, starting at 7 a.m. or whatever. That's something that is attached to the plan that is binding in perpetuity. So if someone comes and complains and says, hey, wait, they're starting at 6 a.m. and it's really noisy, that's something that could potentially be an enforcement action because the plan says 7 a.m. and that's a binding subsequent condition. You should always specify when you're making motions whether you're making them as precedent conditions or subsequent conditions. So that would look something like the board says, we approve the plan subject to the precedent conditions of XYZ. And then you would list what those conditions are. And then in your letter of notification and everything moving forward, that should be clearly stated and written out. What are those precedent conditions? And those should be very clear. An example of how you might use that is, for instance, if your engineering staff reviews a plan and says, these 5 changes need to be made to the plan for whatever stormwater reasons, for safety reasons, and usually they're pretty minor. The board may not want to say, oh, come back, make these fixes and come back next month. The board could say, okay, we approve the plan subject to the precedent condition that these comments from engineering are addressed to the satisfaction of staff. And that means that applicant would have to fix those things, resubmit them to staff, and then staff have to say, okay, check, they met this precedent condition. Sometimes I've seen approvals where they'll say, you can't get your building permit until you set the bounds for the subdivision. It's a precedent condition before the sign off that you set the bounds on the property. So someone would go out there and check, yep, check, they've set the bounds. We can grant the building permit. I know in the community that I worked, once all the precedent conditions were set, then the plans would be signed by the planning board chair. That constituted a final approval. From a statutory and legal perspective, those plans have received final approval. But the conditional approval received at the planning board meeting is not constitute a final approval. You cannot take a conditional approval to the building permits office, or you shouldn't be able to, and say, look, we got conditional approval, give us our building permit. Let's see, did I get everything on this slide? I hope that's clear about the difference between those 2 conditions and how you could handle those. I think I went over this. Yep, be clear which conditions are precedent. Failure to comply means there's no final approval. So if somebody does receive conditional approval, it's subject to, move the driveway from the, usually you don't want to put major design changes as a condition of approval. You usually want to see them, engineer out those changes. But if it is something minor, make this building red or whatever. It's the case that if they don't meet those conditions of approval, they don't ever get the final sign off. I mean, it's helpful for your community to have a procedure for final sign off. What is final sign off? I've been in a case where it was not clear at all when or if they ever received final approval, but the project went forward. Hopefully they did. Hopefully they met all their conditions and it did. But it's really helpful to have a stamp or a signature or something that can happen to say, yep, they met all the conditions, now they're good for a building permit. And if that's part of your procedure, and that's something that you've set up and that you abide by, if that signature is not there, technically that plan has not been approved. And you can also set expirations on conditional approvals. So you can say, you need to meet these conditions within 30 days or 60 days or whatever. You need to meet these conditions within 3 months or 2 years. Usually it's much longer. You have 2 years to meet these conditions of approval. And then if 2 years has gone by and they've never met the conditions of approval, there's no signature, there's no stamp. You could say, hey, you're expired. Your plan is expired. So these are important kind of abilities that the community has to really keep a closer tab on what's going on. And use templates. I like that. Use templates. Notice of decision. So after the planning board has voted, the decision must be put in written form. Again, this should list all the conditions of approval, what types they are, how you know when those precedent conditions have been met. It should document all the subsequent conditions. It should also include specific written findings of fact, basically something, it could be anything from, based on the materials we reviewed, we decided this complies with all our regulations. That could be a findings of fact. If there's a really contentious project, you might want to list more things that you considered as findings of fact. And these, again, should be provided to the applicant or their representative. And you should always keep these on file in your office, and they're considered public documents that you would need to be made available to the public. Failure of the board to make specific written findings to support a disapproval are grounds for automatic reversal and remand by the superior court upon appeal, unless the court determines there's other factors warranting the disapproval. So yes, basically, especially if you're going to do any denial, you really need to say what are your findings of fact? What is this denial based on? What statute, what regulation, what ordinance do they not comply with? What facet of public health, safety, and welfare are they not meeting that was of concern? I think I already went over this too. I'm jumping ahead on myself here. The degree to which a board should make detailed findings may vary based on the level of controversy, as we said. For denials, boards should consider the aspects that made it consider not saying yes. So specific section, oh my gosh, just like I memorized this. So findings of fact should not replace conditions of approval. Findings of fact are basically like, this is what we considered to make this decision. These are the books we read to figure out whatever. Conditions of approval are entirely different. Conditions of approval are extra things that you want them to do or that they need to fix. It's basically like, well, we didn't want you to have to come to the next meeting. This is too minor of an issue, so we'll make it a condition of approval. It can also be, however, though, one condition of approval I've also seen is that all plans have waivers noted on the plan, waivers granted noted on them. So you go to the planning board meeting, you get 6 waivers for some whatever. Then your next task is to update your plan to include all of those waivers that you were granted. So that might be your only condition of approval. You have to make sure your plan notes documents all the waivers that you were granted, and then you're good for sign off. It's not a finding of fact. It's extra steps that you need to make sure that you take, crossing T's, dotting I's, or more significant things like technical fixes, small technical fixes, before you can get sign off and before you can get your building permit. So major and minor applications, the municipality or planning board, they can determine what a major or minor application is. This should be in your regulations. Subdivision and site plan regulations should define. So it can be everything from the number of lots. For 3 or fewer, it's a minor. For 4 or more, it's a major. You make that up. You determine that. You can determine that yourselves. That's not in state statute. That is something the municipality determines on its own. The regulations should include a third-party review as required, as we noted before, for all applications or just major applications. So sometimes you may have a situation where there's an intense traffic impact. And so your regulations might say something like, for these types of traffic impacts, we're automatically going to require a third-party review. And then you need that procedure listed in there. And it can also be at the board's discretion. The board can decide, what, this is really complicated. We don't have anybody to review this. If you don't have regular staff, engineering staff in particular, or even planning staff, it should just automatically be part of your process and written into your regulations. if there's an established technical review committee, what constitutes technical review should be in your regulations as well. The board needs to grant that authority to the committee. And the TRC only has, this is in statute though, only has the authority to review minor site plans. And has to be spelled out what their guidelines are. The TRC, I believe, is technically also a public body. So it still has to notice and provide notice of applications, have the meetings be open to the public. For an actual technical review committee decision that is binding, you still need to abide by all of those notification and public and minutes and all of those things as you would for a regular planning board meeting. Okay. Staff application management processes for staff application acceptance in the office. So these are just some recommendations for how to manage these things. Set your deadline for noon, so you have the day to see what you've got coming in. Don't get in the habit of letting folks push your deadlines and, oh, they submitted at 5 o'clock, or, oh, can we, once you, it's just a bad habit, sets a bad precedent, and you're going to just dig yourself a hole where you're just really frustrated with everything coming in late all the time. It's that whole give an inch, she'll take a mile kind of philosophy. Create spreadsheets so you know what applications you have in, and update them where they are in the process. So this can be extremely invaluable to know what's been conditionally approved and what's been finally approved, especially if your process is very connected, as it hopefully is, with the building permit process and the inspection and review, throughout the life of the project. Spreadsheets can be super helpful to just keep everybody on the same page about what's out there, what's coming in. Consider creating a cover sheet to help the application tracking and quick reference. So here's an interesting one. Do not verify abutters. This is the applicant's responsibility. This is true. It can be really hard though. I've worked with staff, they get the abutters list, and the first thing they do is see if it's correct. Technically, it is the applicant's responsibility to provide the correct list of abutters and to pay the cost of either notice them themselves, or what I've seen is pay the municipality. The municipality is allowed to charge a fee for that, and the municipality will make sure that it's sent out in the timely fashion. If the notification is not met, the applicant is basically leaving themselves open to whatever, so a challenge and the validity of the public hearing, and having that turned over. So, usually I've seen municipalities take care of these things, but it really is not the municipality's fault if anything is wrong, or it's not their responsibility if anything is wrong, or if it's not done correctly, because the municipality is not liable. It's the applicant that is liable. Set an abutter submission policy based on the number of abutters, and you don't have to make copies of applications for applicants. You're not required to do that because that can be expensive. They should be providing all the copies required themselves. Staff application management, continue reveal application materials for all submission requirements, not for content requirements. So your initial run through there should be basically, do they have everything that's on our list of things that are required? It's a good idea to inform your chair, hey, we got 3 applications this month. If you have a process for fees and escrows, that's that would go right along with accepting the application. Once you establish you're going to accept the application, then you do your fees and your escrow funds. It's not a great idea to process your fees and then decide, oh wait, they don't have the checklist, we can't they don't have XYZ, we can't accept this, because that can create like a financial or just a really stressful situation if they don't proceed, or if you end up having to return it to them. So then after you've established all that, you create your public notice and butter notices, and you prepare the packets for the planning board. It says packets, but this can be a digital packet or a hard copy packet, something that you're emailing to them or something that you're providing them paper copies, whatever your process is. I think more and more folks are moving towards not printing and mailing or dropping off paper copies, but attempting to get everything digital, especially if your requirements for the submission are digital. So if you are, I know some communities now only have digital online requirements for plans. So yeah, it does. You should definitely not be printing those out and sending them to the planning board members. If you want hard copies to send planning board members, make sure you're requiring them to give you hard copies. Rules of procedure. I think this has been gone over a couple of times already today. I won't spend too much time on it. This is do not use Robert's rules. I think it just means don't, make them your own. Don't copy Robert's rules. You need to have your own rules of procedure. You can use these as, references, but you really need to adopt your own rules of procedure that apply to your body and, the date and time of your meetings and based on the amount of staff and resources that you have, and also how the meetings are to proceed, how people should behave, what your expectations are. So yes, I won't go belabor that too much. And also follow your rules. I think that's been said multiple times. Follow your rules of procedure. What is a zoning amendment? So a zoning amendment is any change to the ordinance. So the zoning ordinance is something that's adopted or approved by the elected officials of your community. The planning board may, depending on your community, the planning board usually reviews the zoning amendments first and gives a recommendation that they approve them or whatever. But it's the elected officials of your municipal body that approve that approve zoning ordinances. An amendment is a change to those ordinances. So it could be the language, it could be a table, it could be your zoning map. Any change to that document has to go through the process for a zoning amendment. So as cities and towns, they can do this any time of year, but a town council, towns and village districts, they can only do these once a year by ballot at their annual meeting. So there's four types. Well, there's types of zoning amendments. The planning ways that a zoning amendment can be introduced. The planning board can introduce a zoning amendment. That's noted under 674(1). The governing body, the actual elected officials themselves, they can propose zoning amendments. Petition zoning amendment. The public, members of the public, 25 or more registered voters can petition for an amendment to zoning ordinance, historic village, or a building code. So the zoning amendment, this is saying correct format review with town clerk, which you can do, if you're reviewing your planning board or whatever, but you can't, if the public submits a zoning amendment proposal, the town staff cannot change that and say, oh, we think you mean this, or you have a typo or whatever. No, that what they submit is what it is. You should be correcting language and things like that. But reason justification statement along with the amendment, these are things that you should be including with your submission. Is the planning board in support of it? What's the reason or justification? And like I said, governing body and petition amendment language can't be changed. So if your elected officials propose a zoning amendment, it is what it is. When they can debate it among themselves or make changes. So more on petition zoning amendments, 25 registered voters can get together and amend or repeal a provision of the zoning ordinance, historic district, or a building code. They must be received between 120 and 90 days before the town meeting. The petitions are submitted to the governing body, and they forward this to the planning board. As I said, usually the planning board is going to review these to either make recommendations or comments or express their support. At the first planning board meeting after the petition period, the board shall set the date for the public hearing on the petition, and the petition amendments cannot be altered by the planning board, but the board shall state if it approves or supports, or they can make recommendations on like things they think should be changed to make it better. They'd support it if it did this, or that other thing. How to be a good board member. So do your homework. And I guess that means like just review what's before you ahead of time to make sure, to the extent that you're able, that you're aware of what the applications are. This is actually a lot of work, and that's why it can be difficult to find, I think, planning board members, depending on your community and how active it is. Reviewing applications and really understanding the issues is quite a bit of work, but that's what makes it flow smoothly, and you're able to participate and ask informed questions. Be fair and unbiased. Attend to the meetings. Be on time and look presentable. So kind of obvious aspects of just public presence. You work with staff on learning the ordinance if you have staff. If you don't have staff, I guess you get access to the ordinances and try to review them yourselves. But our agency and others are always trying to create more resources to help citizen planners and board members to understand that, through trainings like this, what the rules are and what the procedures are. So if you have staff, work with them to the best that you can to learning the regulations and the ordinances. Cooperate with other boards. Don't be in a silo. Be respectful to members of the public and board members, and do not communicate via email, which is 91A. Too many members communicating, well, if you get a quorum communicating on email, you're in violation of 91A. And just in general, this is not a good idea to communicate about projects outside of a public meeting. And ask your municipal attorney if you have any questions about conflicts of interest or procedures or 91A or anything like that. Do not use social media to discuss applications. That would just get you in some hot water, because it might look like you have preconceived notions about a plan. Do not develop or express, well, what I just said about any application. Do not abstain. Sometimes there's a tricky application, it's really contentious, and people want to abstain because they don't want to be a bad guy. But abstaining can be really problematic if you're not doing your job, basically. You don't want to be the bad guy, but the decisions have to be made. Cases where I've seen where it kind of makes sense to abstain is if a meeting's gone on for, if there's a project that's gone on for like 3 months or 4 months, and you didn't catch any of those meetings, and you caught the very last one where they were going to vote. Maybe it makes sense to abstain. You haven't kept up. You don't really know what's gone on. But just because something is contentious or complicated, it's not helpful to have members abstain. Again, recuse yourself when appropriate if there's a conflict of interest. Juris standard, expect to gain, lose from the case. Here's what, more information about. I think we've gone over a bunch. So yeah, hopefully that was helpful. This is our contact information. If we don't know the answer to something, we will look it up for you, or we'll find somebody who does. So you're welcome to reach out to us if you have questions, or if you need more training. We'd like to know as well, what topics do folks need more training on or need more education on? So I think Brendan might have said, hey, if there's a topic you want us to cover, let us know, because we have a platform and we like to be of the best assistance possible. Reach out to us and say, hey, I really don't understand XYZ. And, if we find enough people that don't understand XYZ, we'll maybe make that a topic. But I'd like to open it up if folks have some questions. I hid my chat because I kept getting too distracted by it, and now I don't know how to open it up again. Brendan, are there any more questions?
Yeah, we've got a couple actually. One pertains to the last topic you just talked about,
Yeah.
with recusals and abstaining from votes. So they asked, can you recuse and let an alternate vote instead of abstaining?
I'm not sure what the situation would do something like that. If there is a conflict of interest, that's an interesting question. I don't know if it makes sense to be like, you're in the planning board meeting and a project comes up where you have a conflict of interest and you just say, you know what? I'm going to step out and let Jody step in because she doesn't have a conflict of interest on this one thing. I have seen situations where you had invited your alternates to the meeting. So maybe you've got, you only need, seven and you've got 11 or whatever, however many, I can't even recall. This has been a while. And so you step out and you recuse yourself and then they're kind of two different situations. Um, Abstaining might be more like you have, like I said, I really can't think of too many examples. That's why I only gave that one. Abstaining. It's not a great procedure unless there is a conflict of interest where you shouldn't be involved, and that's a completely different situation.
Yeah, and I think it's a good thing to I think John touched on this a lot too, that if you do have a conflict of interest, don't abstain, recuse.
Yeah,
Really
exactly.
just get out of there, because
Yeah.
it's better safe than sorry. Um,
Exactly.
but
Recusing means that you remove yourself from the board and you're no longer a board member. And we were always suggested that you leave the room so that you didn't influence the board's decision because they know you're in the room and they know that you have a stake in this whatever thing and it might cause whatever. Um, so abstaining is more like, well, I've sat through the whole thing. I've sat through the presentation and all of the material. But I'm going to abstain because again, there was like three other meetings when I didn't hear any of that discussion. And it's not appropriate for me to vote based on just this one meeting. So there's no conflict of interest. It's just maybe you're not the best judge, but you didn't necessarily have to recuse yourself. Is that the
mhm.
only I was answering questions kind of right along. So I answered the one about the conditional use approvals, hopefully, um,
Yeah, there's another
effectively.
question kind of about the conditional approvals, and they asked, are covenants handled like conditional approvals?
Hmm. Covenants, a covenant can be a condition of approval. Uh, a covenant can also be required, you know, something that you want, depending on what the covenant is, it can be something that really should be done before they even get a condition of approval, depending on the project. But if it's something that is like a more, I don't want to say technical, but you just want to make sure that you have a situation squared away legally. It's not a major issue. Like I would suspect that could be a condition of approval to have a fees. But again, I think it would really just depend on the that you would want to see that's occurred beforehand. It could, related to like the property ownership or the parties or, uh, you know, so depending on who's presenting the submission and what their rights are in the property, so I think it would really just depend on whether that's something that should be already in place, or something that you end up having a condition of approval. I would think though, if you did make it a condition of approval, should definitely be a precedent and not a subsequent, because it was something that you really needs to be in place. You don't want to give them permission to move forward on the project until they actually have that covenant, or they may never do it. If it's a subsequent condition, unless you're saying this is I don't know, that just gets a little bit more complicated. Subsequent conditions are binding, but there's usually not really like a time frame or a mechanism for enforcement of something like that.
Mm. And so somebody just put in the chat as well, kind of a follow-up question to that is who enforces violations of covenants? Do these come from the planning board?
I'm trying to think of a situation where I had experience with that.
Yeah, I always think of covenants as being more part of HOAs, and
Yeah,
that
me
it would
too.
it
I'm
would be
not
the
sure.
HOA's
I mean,
kind of
or
responsibility.
conservation land and conservation
Mm,
easements. So I suppose it depends who the parties of the covenant are, or who the strict, who has standing in the covenant and who is represented in it. If it's something that if it's something that is like, for instance, I know in the city of Concord, they never wanted to enforce like condominium documents, because a condominium document is an agreement is a private agreement, right? So covenants, you know what? I think we should say that one to the end of the day. Can we mark
hmm
that one down to ask one of our attorneys? Because I don't know the answer to that.
Yeah, yeah, absolutely. Yeah, that one's a little can be a little complicated.
Oh,
All right,
covenants
let's.
recorded at the violation of a covenant recorded at a deed office. Again, I almost want to say that might be a private issue,
hmm
unless the covenant is with the municipality and the municipality is the one who is, aggrieved by it. If then
hmm
it would be the municipality, somebody, the legal office, or hiring a solicitor or somebody to take that to court to,
Yeah,
address it.
yeah. I would
It's a
think
hard
that.
question to answer without more specific. Each situation sounds like it might be a little bit specific. Might be a little bit.
Yeah,
I mean, if
that's
you have a
that.
covenant, if you're a business in operation and it's written in a way that says, your permit is subject to this covenant being in place, well, then you could, you know, uh, reject that permit, or, um, not you enforcement actions against the permit. So it really depends, I think, who are the parties involved, and what is it in place for.
Yeah. Um,
But it sounds like what I'm avoiding saying, it might just be a private uh, issue between two private parties where
mhm.
they need to hire an attorney.
Yeah, yeah, that's what I'm thinking as well. Um, so let's see another question from on a different topic. This came in a little earlier. Can an applicant object to the need and or cost of a third party review? So like a traffic study or something like that.
um sure. I mean, it just depends how it wants to handle that situation. If they say, uh I mean, if the municipality has procedures in place that says we can do this, we have the authority to issue this fee, um, and that the consultant gives you the cost of the fee, that's the consultant's fee, right?
hmm
In no circumstances should the municipality be covering whatever cost the applicant has a problem with. If they say this is going to cost us $3,000, it's $3,000. That's from a private consultant. Then it becomes like, okay, we're not going to do it. We're not going to move forward because we can't pay that. Um, but the municipality should, unless they want to, for whatever reason, okay, we'll pay 1,500 and you pay 1,500. Like, no, I haven't really seen that. So, in some ways it might be kind of like going to the store and being like, I don't want to pay this price. And they're like, okay, well, don't buy that,
hmm
because it's a private consultant.
Yeah. And just really quick, before I ask the next question, I do see that there is somebody with their hand up. We don't have the ability to unmute anybody,
Yeah,
so if you
please
do have
put
your
your question in the chat.
yeah, you can put your question in the chat. We do have a few more minutes, and again, we've got a whole Q&A session directly after this one, after a short break. Um, but let's see. Let's see. One more question here. Can Oh, here we go. So can zoning amendments be worked on by just one member, or should a subcommittee be formed? And I always think of zoning amendments as being more like when the planning board's coming up with a zoning amendment, they're usually doing it as a group, like at during a planning board meeting, right? As it's not usually
Well, I think it
one.
depends if you're doing the petition. If it's a petition from
Mhm.
community members, like you need to get 25 people to say, we want this. Otherwise, if it's the, elected officials or the planning board who's doing it, yeah, they can do it however they want. I would say unless they have some training or in planning or legal documents or legal work, that's probably a good idea to get a group together to see what makes the most sense, and run it by different people. And same thing with staff. I've worked as a solo person and didn't mind it so much, but it's really hard if you're the only person that's worked on something to present it to a group. It's important to have buy-in and multiple perspectives, because more people, zoning ordinances can be complicated, and the more people you have that can sort of say, oh, hey, wait, I saw this section, are you sure this is okay based on that section, the better. So it can be both, it can be either, unless it's the petition, you need 25 people.
Mm. And let's see, we've got maybe we'll do one more question here, unless I see another one come in. So, what is the best way to handle an applicant who ignores conditions' subsequent actions? Enforce case examples. So, somebody who's ignoring conditions
Yeah,
subsequent.
yeah, I mean, then you get your, it's good question.
That that one might be for
It
attorneys.
really becomes a legal, I mean, once something's built in an operation, there's so little that a community can actually do, right? Unless there's like something that can be revoked. We revoke this permit, you no longer have authority to operate this restaurant or whatever. Um, Legal action through your solicitor or is really in some ways, if you unless you have some other tools, like you have the authority to enforce, you have that authority, but if you don't have any tools to enforce it, I would just say consult with the attorney to see what you have, tools you have available to use in that situation. They have none other than like, well, we're gonna issue a cease and desist, and then we're gonna, file this, and then we're gonna file that. So it's better just to see if you can work something out and get, you know, but I would consult with attorney.
Yeah, and somebody else put in the chat that the planning board has the ability to hold a condition compliance hearing as
That would
as
be
well.
great.
So yeah,
That
so
would be
there's
great. But it's
ways
always
to.
like, wait, what is our stick, you know?
Hmm.
Um, it's important consideration. If you want to know that they're going to do something, you have to have some leverage somewhere. And so that's why it's important to put most things before, as precedent, because you're building leverage that you have. But then those like hours of things, it's challenging.
Hmm. Yeah, and the
But I
same
like that
person.
condition of compliance one.
Yeah. Um, yeah, so I guess I think that's all of I believe that's all the questions we got
Great.
for this session. And we are going to go on a quick break here until what time?
15, I think.
2:15? Okay. Yep, 2:15. Yeah, so the next session starts at 2:15, and that is the planner is in. We've got Mark, Heather, who's here with us, and Carol Ogilvy will be there to answer any remaining questions that are left over from the past few sessions that we have. So, all right. And with that, here, let's see. I'm going to grab the slides and There we go. All right, I will see you all back here at 2:15. Thank you.